3, the sweet spot for me. So I think we can go ahead and get started. So for those who joined after I made the announcement, this is going to be an interactive Zoom. If you have questions, 3, the sweet spot for me. Give me a second. I think we can go ahead and so that was my computer. It went live and it was sharing with me, and I didn't need it to do that. So if you have questions, feel free to go ahead and jump off of Zoom and ask the questions. You can raise your hand and I'll be happy to answer them. You can write it in the chat if you want to write it in the chat. So welcome, everyone. This is Entrepreneur Essentials, securing and protecting your trademark. I am happy that you all are able to, that I'm able to speak to you all about this topic. My name is Danielle Brown, and I'm the founding attorney of the Brown Firm. I've been practicing law for over 10 years, and I love helping businesses of all sizes secure and protect their valuable intellectual property. I work with a lot of entrepreneurs doing this type of work. And throughout my career, I've had the opportunity to work with major brands across various industries, providing some of the strategic counsel and guidance to protect their trademark and maintain their competitive edge in the marketplace, right? I'm really passionate about helping entrepreneurs and business owners to navigate the complex world of trademark law. And I look forward to sharing my knowledge with you all today. So thank you again for joining. And I hope you find this webinar informative and valuable. Also want to note that you can find us on social media. We're on Facebook, Instagram. We have a LinkedIn page as well. And so I'll go ahead and get started. So on today's agenda, I want to cover a few things, right? Making sure everyone understands what trademarks are, want to understand the trademark registration process. Also want to make sure you understand protecting your trademark. Then I want to give some tips and some best practices, and then we can open it up for a Q&A session. So understanding trademarks. First, I think in order to understand trademark, we really need to understand what the other intellectual property rights are, right? So we need to understand what trademark is not. So copyrights. Copyrights protect original works of authorship, such as literature, music, and artwork, while patents protect inventions and ideas, right? So oftentimes I'll have a client come and say, oh, I need a copyright or a patent. I don't really know which one, right? So that's how you distinguish. Copyrights protect original works of authorship, whereas patents protect inventions, any new ideas, any new systems, and then trade secrets protect confidential business information. So what is a trademark? A trademark protects a company's reputation and goodwill by ensuring that competitors cannot use similar marks to confuse consumers or misrepresent their own products or services as being associated with that trademark owner, right? A trademark is really anything that identifies and distinguishes the source of the goods or the services of one party from those of others. So most trademarks are comprised of words or images or a combination of the two, but anything that can identify the source of goods or services can actually be a trademark. And examples of common trademarks are brand names or logos or even slogans, right? And the core purpose of the trademark law is to allow consumers to have confidence in the accurate labels that companies have, right? And have confidence in other information that tells them where goods or services come from. This allows the trademark office, this allows a consumer or a trademark owner to build trust and consistency with the quality of their brand, right? So the trademark law is to protect against that. So there are different types of trademarks. And sorry, just move this screen out of the way. So there are different types of trademarks. And The first is word marks, and word marks are perhaps the most common type of trademark. A word mark is a trademark that consists of only words or letters without any design elements. So some examples include brands such as Nike, Coca-Cola, or even Google, right? And we're all familiar with those brands. And word marks can be made up of anything from a singular letter or a number to a long sequence of words, right? And examples include Nike's "Just Do It," that's a trademark, or McDonald's "I'm Loving It," right? Or even Coca-Cola's "Taste the Feeling," right? So there are also another type of trademark is a design mark. And a design mark is a design that includes a unique, is a trademark that includes a unique design or a logo. So some examples will include the Apple logo, right? Or if you even think about the Starbucks mermaid, or even the McDonald's golden arches, right? Those are all design marks. And then you have trade dress. And trade dress refers to the distinctive packaging, the design, or an appearance of a product or service that identifies and distinguishes it from others. So some examples include the unique shops of the Coca-Cola, the unique shape of the Coca-Cola bottle. I see I have some questions. All right, it keeps freezing. All right, cannot hear. Is everyone having an issue hearing me right now?
I can hear you.
Awesome. Thank you, Renee. So as I was saying, so trade dress refers to the distinct packaging, design, or the appearance of a product or service, right, that it identifies. So the Coca-Cola bottle is an example of trade dress, right? That's a distinct product design. Also, the red and yellow of the scheme of McDonald's restaurants, that's a distinct appearance that is associated with the McDonald's chain restaurants. But there are also some non-traditional trademarks, and those can be colors, sounds, smells, anything else that I didn't mention that is a source identifier. All right, so some examples of color trademarks will include the UPS brown, right, or Tiffany's blue, or even T-Mobile's magenta, right? And I want you to note that the protection for those colors extends only to similar goods and services, right? So they don't own a monopoly on those colors. It's not that you can't go out and utilize those colors. You just can't utilize those colors for the services and the products that they offer. Right, so they don't own the colors per se. Then you also have sound trademarks, which include Yahoo's Yodel, or even NBC's chimes, right? When you're watching NBC, you hear those chimes, you know it's NBC. Or the MGM Lion is another good example, right? And then there's also, like I said, smell marks, right? A good example of that is Play-Doh. When you smell Play-Doh, you know that it's Play-Doh. And sometimes you may wish you didn't smell the Play-Doh, all right? But it's important to know that trademarks can also be a combination of all of these types, such as a word mark with a specific design element, or an example of that would be Google, right? Or a slogan with a specific color scheme. So it's not that you have to use all of these separately, you can combine them and that can make up your trademark. So what are the benefits of trademark registration? Well, one of the first benefits is that you can be on the USPTO database, right? And this provides public notice to anyone searching for similar marks. And they will see that your trademark is there. They will see what goods or services your mark is affiliated. They will see what date you applied for it, and the date that your trademark was registered, right? So that they can't claim ignorance if they were to be found to be infringing on your mark. Another benefit is that you have the exclusive rights to utilizing that mark. So registering a trademark provides you with those rights and connection with the products and the services that you offer, right? So it's not that you have an exclusive right to use your mark all throughout the world, et cetera. But an example would be Dove soap and Dove chocolate, right? They're able to coexist with the same name because they operate in different spaces, right? One is candy and one is hygiene products, right? So they have the exclusive rights to use it within their fields, so that they can prevent others from utilizing similar marks that may confuse consumers. Another thing is you have the right to use the R, right? When you get a federal trademark registration. And what this R shows is that you're registered with the USPTO. It shows that folks shouldn't utilize it without your permission, right? This may help deter others from using your trademark or one that is too similar to yours. You also get some legal protection, right? The legal presumption that you own the trademark and have the right to use it comes with a federal registration. You also are able to sue in federal court, and your trademark registration certificate proves that you are the owner of the trademark. It eliminates the need to get copious amounts of evidence, right, to prove ownership otherwise. So that's something to keep in mind. You also have the ability to register and record your registration with the U.S. Customs and Border Protection. And this is really for folks who provide goods, right? When you register with the U.S. Customs and Border Protection, what you can do is you can stop the importation of fake goods, right? So they stop people from infringing on your mark. Because you don't, sometimes you'll have folks who make counterfeit products overseas and then they try to import them. Well, this will stop that. You also get additional brand recognition, right? A registered trademark helps to establish brand recognition and can increase the value of a company's products or services. It also allows customers to easily identify and distinguish a company's product from those of its competitors. But then there's licensing and franchising opportunities. You can begin to license out your trademark or franchise it out, allowing others to use the mark in exchange for payment or even royalties, right? And this can provide an additional source of income for you as the trademark owner. And last but not least, you can also register internationally and using the basis of your U.S. application to establish priority, right? So a lot of countries, when you're trying to register your trademark internationally, you need to establish priority, and this will help you do that. And it makes expanding your brand easier. So what is the trademark registration process? Well, the trademark application process can be complex and time consuming, but it's an essential step in securing the trademark. And here's an overview of the application process. And I'm gonna walk through them individually. But essentially you have a trademark search, there's an application, it's reviewed, and then it continues on through that process. And I'll walk through each step of that process now. So the very first step of a trademark application should be a trademark search. It's an important step in establishing and securing a trademark for several reasons. First, you want to avoid infringement. When you conduct a trademark search, it can help you to avoid infringing on existing marks by knowing what's out there, right? If a proposed trademark is too similar to an existing trademark, using it can lead to legal action, and you don't want folks suing you. And that can result in costly legal fees. It can result in damages and potentially requiring a rebranding effort. It also saves time and money. When you conduct a trademark search before investing time and resources in developing a new product, you can save that time and money. It can prevent you from spending money on like developing a product, for example, right? And then having a switch when you find out that your application was denied because there's a similar product already registered. So that's something that you'll want to keep in mind. It also increases the likelihood of registration. Conducting a trademark search prevents you from conducting a trademark search prevents you from trying to register a mark that already exists, right? So if you conduct a trademark search, you'll be able to see if there's something too similar, right? And a lot of people get confused. They think that it must be an exact mark, and it does not have to be an exact mark at all. It just needs to be too similar and could potentially cause confusion amongst consumers, and it can get rejected, right? So when you work with an attorney who can help you identify whether or not it's close to another mark, the trademark search can help you increase your likelihood of registration. And another thing is, like I said, working with an attorney is almost essential for this, right? Because an attorney has a more comprehensive database that they work with to determine whether or not a mark is available for registration or use, right? And they can perform a more detailed analysis. Also, they can interpret search results, right? So your search report, if you conduct a search report on your own, your search report might say that there are 1 million marks out there that are similar to it, but which marks are really relevant to your mark, right? And working with an attorney can help you establish that. But also, it can provide you with legal advice. The attorneys can provide you with legal advice, right? An example would be I've had clients come from LegalZoom, and they've told them that they can't proceed with a particular trademark that they've searched, but they don't tell you what's the best strategy to move forward, right? When you work with an attorney, you have the benefit of getting that legal advice and developing those strategies. As I said, if you have any questions or anything like that you want to answer, please feel free to come off of mute, and also you can write it in the chat as well. So then we move on to the application. And when you're doing the application, you need to determine the filing basis. So there are 2 filing bases for trademark applications, and one is a use in commerce, and we call it a use-based application, or an intent to use. A use in commerce applies to trademarks that are currently being used in connection with a product or service, right? While intent to use applies to trademarks that are not being used, but are planned for use in the future. Then you want to prepare and file the trademark application, right? So the trademark application must be filed with the U.S. Patent and Trademark Office. This gives you federal protection. A lot of people have said, oh, I want to file a state registration. I typically don't recommend that. It would have to be a very unique situation, because a state registration only gives you protection in that state, right? Whereas a U.S. protection, the U.S. Patent and Trademark Office gives you national protection, right? So you want to make sure that you complete this application, include the proposed mark on this application, include the goods and services that are going to be associated with the trademark. You want to make sure you get the right filing base, and you want to make sure you pay the filing fees. And then you proceed on to the application review. Right. So once it's submitted, it'll be assigned to an examining attorney who will review the application and conduct a search of existing trademarks to determine if there are any conflicts. If the examining attorney identifies any issues with the application, they will issue an office action, which is a written communication that identifies the issues and provides a deadline for responding. You want to make sure you respond to the office action, right? A lot of times I know a lot of folks get office actions and they think that that's the end of the road. That is not the case, right? You have actually 2 opportunities to respond to an office action, right? So if an office action is issued, the applicant must respond within 3 months. It used to be 6 months, but they lowered it to 3 months, and you can ask for an extension if necessary to make it the 6 months, right? But your response to the office action has to address the issues identified by the examining attorney. So if the examining attorney says that they think that this mark is too similar to another mark, you can't respond saying, but I've been using this mark for 5 years, right? That's not an adequate response to, you should address the issues that the examining attorney brought up in the office action. And then if the application is approved, either if you succeed in responding to an office action, or if the examining attorney found no issues, it will then be published in what's called the Official Gazette, which is a trademark publication, and it's published there for 30 days. And it's a 30-day window for others to oppose the registration of the trademark, right? So that's if another trademark owner thinks that your mark is too similar or is likely to cause confusion, etc. And then it proceeds on to registration if there are no oppositions, right? Or if an opposition is unsuccessful. At that point, the trademark will be registered and you'll receive a certificate of registration. So the trademark application process can be complex and time-consuming, but you have to make sure that you conduct that process. All right. And then once the trademark is registered, you have to make sure that you maintain the mark, right? And this is crucial to make sure that your trademark remains in force and provides you with ongoing protection as the owner. So there are a few steps in maintaining the mark. The first step is making sure that you renew your trademark periodically. So the USPTO office, which is the US Patent and Trademark Office, they require you to do it. So there's a renewal the first year in between the 5th and 6th year, and then the 10th year from registration, and every 10 years after that, right? And to maintain the registered trademark, you must make sure that it's being used in commerce. You can't just stop using the mark and keep registering it, right? The renewal is to ensure that you're actually using the trademark at least periodically, and that's the only way for you to maintain that trademark. So failure to use a trademark can result in the registration being canceled, excuse me.
I'm sorry, I have a question.
Yeah.
So if you are filing for an intent to use trademark, is there a certain amount of time that you have before it has to be in commerce?
Yes. So great question. When you file an intent to use trademark, it goes through the process that I outlined. And then once you get to the publication period and there's no oppositions, what the examining attorney issues is a notice of allowance, right? And what that means is that you have 6 months to provide evidence of how you're utilizing this mark in commerce. However, if you can't provide that evidence within the 6 months, you're allowed to file extensions, and you can file up to 5 extensions, right? And what that essentially gives you is 3 years to provide evidence to the USPTO.
I see. Thank you so much.
Absolutely. Great questions. So with regard to maintaining the trademark and filing your renewals, you also want to make sure that you're deleting goods and services from your application that you have no intention to provide anymore, right? So if you stop using your trademark with one or more of the goods or services in your registration between required maintenance filings, you should delete them from your registration, because what happens is someone can challenge your registration and potentially cancel your mark because you're not using it how you said you were utilizing it. And then there's international protection, right? So in most countries, I think I mentioned earlier, the right to a trademark is based on the first to file principle. Therefore, it's important to file a trademark as soon as possible. And establishing your trademark and registering your trademark here in the US could potentially give you some priority in other countries. Another system is the Madrid system. It's an international treaty, essentially, that allows for the filing of a single international application for trademark registration, which can simplify the process of securing trademark rights in multiple countries. And it's administered by the World Intellectual Property Organization, right? But it's important to know that not all countries are a part of this this treaty, right? So there's some countries that aren't, and Nigeria is an example of one, right? South Africa is another example. But you know, this can be helpful if they are a part of the treaty. And then some regions have established regional trademark registration systems, such as the European Union Intellectual Property Office and the African Regional Intellectual Property Organization, which can provide a streamlined process for securing trademark rights in multiple countries within that region. And then there's some national filings, right? In some cases, it may be necessary to file a trademark application directly in a foreign country to secure trademark rights in that jurisdiction. In these cases, it's important to work with a local attorney or agent who has knowledge of the local laws and regulations. And then also, you want to make sure that you're enforcing your rights that you secure in those foreign countries, right? It's important to monitor for potential infringement and take action to enforce those rights, which may involve working with local attorneys and enforcing trademark rights through local courts. So then you want to make sure you're protecting your trademark, right? So the first thing you should do when you're protecting your trademark is to monitor the use of the trademark to identify potential infringements. And this can be done through online searches. Most firms, including our firm, will offer trademark watch services. And what the services include is that we'll do a search every 2 weeks, write you a letter on any marks that we've identified that are infringing on your mark, and give you a strategy on how to move forward, right? And that's where enforcement comes in hand, right? If an infringement is identified, the trademark owner should take swift action to enforce their rights. And this may involve sending a cease and desist letter or filing a lawsuit to stop them from you doing the infringing activity and seeking damages. And it's important that you actually enforce these rights because your trademark can lose its protection. And there's been plenty of companies who've done this, right? An example would be Escalator. Escalator was a brand name, and now we refer to every moving step as Escalator, right? Dry Ice is another example. It was a brand name, and then they didn't stop people from utilizing it as a trademark. They didn't enforce their rights, so they lost the brand protection in that, and it became just a generic term. All right. You also want to make sure that you establish brand guidelines, because establishing and enforcing brand guidelines can help to ensure that the trademark is used correctly and consistently, which can help to build brand recognition and protect the trademark. And then, you know, contracts are also important, such as license agreements and distribution agreements, right? These can include provisions that protect the trademark and prohibit unauthorized use of a mark. So what are some tips and best practices for entrepreneurs who are pursuing trademarks? First, I think one of the most important things is making sure that you choose a good trademark. The strength of any particular trademark will depend on the mark's capability to distinguish itself from other goods or services, right? And generally, the strength of a mark is categorized along a spectrum of distinctiveness that ranges from generic to fanciful, right? And generic includes common words or generic descriptions that fails to distinguish the source of goods or services from another. These are incapable of trademark registration, right? So some examples are bicycle, aspirin, bleach, a pen, cup, right? Those are just generic terms. And then you have descriptive terms, words that reflect the content, the quality or the characteristic or function of a product or service, right? And these are only protectable if there's some secondary meaning that is acquired. An example would be the Container Store or public storage, right? And then you have suggestive marks. And these are marks that suggest a particular quality or characteristic of the goods or service. And these marks, excuse me, these marks require the consumer to think about what it represents. An example would be TripAdvisor, Under Armour Copper Tone, which is like a sunscreen lotion, right? It's suggesting that you'll have a copper tone. And then there are arbitrary marks that have a common meaning, but the meaning is unrelated to the product or service it actually represents. And an example would be Apple, right? Apple existed, but it wasn't a technology company, or Amazon. It's not a bookstore, right? And then there are fanciful marks, which provide you with the most protection. And fanciful marks are marks that have been invented for the sole purpose of acting as a trademark, right? So you have ExxonMobil, you have Lululemon, Google, right? What was Google before Google? You have Adidas, right? So those are brands that were just made up to identify that particular group. So like I said, selecting a trademark that is distinctive and memorable is helpful in choosing a trademark. You don't want to make it too generic or descriptive because it may be difficult to protect it or to enforce it. And the strongest trademarks are those that are arbitrary, fanciful, or suggestive. All right. All right, there we go. So some additional tips is you want to make sure you avoid confusingly similar trademarks. So before selecting a trademark, you should conduct a comprehensive trademark search to avoid selecting a mark that is confusingly similar to an existing mark. And this can help avoid any legal disputes, right? So I know a lot of times people would want to play off of a brand name, like Coachella, they may say, Girlchella or something similar, right? Depending on what you're utilizing the mark for, that can be problematic. That can potentially bring you legal disputes. Some words you may want to, some marks you may want to make sure that it's easy to spell and pronounce, because it can make it easier for consumers to remember and recognize the brand. It's not to say that you can't make up a word, just making sure that people are able to pronounce it will help you establish goodwill in the market, etc. You may want to avoid geographical terms, right? Because these are sometimes considered weak and difficult to protect, right? Most times they have to gain some secondary meaning. And that was the case for Coachella. Coachella is a place in California, and they needed to gain secondary meaning, and they did. And then you want to consider future expansion. You want to select a mark that can accommodate that future expansion and the product lines that you may have. This can help avoid the need to rebrand later on. And then if you plan to market your brand in other countries, you want to consider cultural and linguistic differences to ensure that the trademark is not offensive or inappropriate in other languages or cultures, because that can get you denied as well. Any questions?
Yes, this is Sharon. I do have a question. Going back to what you said earlier about, and you can correct me if what I'm reiterating is inaccurate. But earlier you mentioned that trademarks allow you to monetize. And I wanted clarity on how that's done.
So are you talking about the licensing and franchising opportunities that I was referencing?
Yeah, I think that's what you mentioned as well.
Yeah. So, when you are starting a brand, if you have a trademark brand, depending on how much goodwill you build up and how recognizable your brand is in the market, some people may want to establish a similar brand, right? So an example would be McDonald's started out as just a burger place, right? And then they were able to franchise that burger place out and create different opportunities for them there, right? So that's one idea. And that can create some revenue for the entrepreneur. Second is licensing. An example would be Disney. Life does a lot of licensing deals, right? If your brand is popular, they might want to do a joint project, and you can create a license deal with them where they can go ahead and utilize your mark or do some co-branding, and that can create some revenue for you as well.
So would that also be considered like some type of like, would that be in that scenario that you just mentioned, would that also be considered like a form of a what you call it, like an endorsement deal, like, or similar to that?
It's similar, right? But licensing is really where you're allowing another company or another brand to utilize your mark, right? And you're saying, so the license can be exclusive or it can be non-exclusive. You can say, hey, you can use it for this specific purpose. That's really what licensing is. So it's similar to endorsements, but with an endorsement, it's typically about your likeness, etc., right? And utilize. So for example, if Nike endorses an athlete, they'll provide them with benefits so that they can use that athlete's likeness, their image on different merchandise, right? So it's similar, but licensing, it has to do with your trademarks and your brand.
Okay. Yeah, that I get it now.
Awesome.
I also have a question.
Yes, Renee.
If you have an organization, right, with a brand, let's say maybe a services organization, and maybe now you want to do events or something like that, would you license like a term or a name of an event or like a reoccurring experience, so to speak? Like, does it make sense to trademark something if it's not like the company or the organization? Like the organization then goes into areas of experience or pop-up shops or events. Would you trademark, let's say, that title or that theme?
Absolutely. So, brand names or company names are just one example of a trademark. Any reoccurring experiences that you want to create and you don't want other people to utilize, you should absolutely trademark, right? So let's say I have a company called We Throw the Best Events. And then one of my events is, I'm not very creative, right? That's why I'm a lawyer. But one of my events is Show Up, Show Out, right? If Show Up, Show Out is a recurring event and I want to build goodwill around this, and I'm going to do multiple of these events, then I would go ahead and register Show Up, Show Out as a trademark as well.
Okay, so that's very helpful. And then let's say you register Show Up, Show Out, and it's approved, and then you see T-shirts in your neighborhood with Show Up, Show Out. Is that something that you could enforce?
So no, right? And the reason I say no on that example is trademark registration comes in connection with what you do with it. So remember, I gave you the Dove example. You had Dove soap versus Dove chocolate. They exist in that space, right? So if a part of your trademark registration was, if your trademark registration only covered event creation, event promotion, etc., and you didn't have any clothing, then you would, the mark wouldn't cover it, right? It would be outside of your space. However, if you filed an application that included merchandise that you were going to start a clothing brand as well as do the event services, then you would be protected. Does that make sense?
Yes.
And just in general, that's a great question. There are 45 classes of goods and services, and you don't necessarily need to register in a particular class for you to be protected. An example would be if I own a bar called Drink It Up. I told you I'm not creative, right? Called Drink It Up. And then I have a beverage called Chocolate Delight. Drink It Up. If my bar services is covered as Drink It Up, if I registered that mark, and then someone else tries to create a beverage, an alcoholic beverage or whatever the case may be, with the title Drink It Up, well, the trademark office will prevent that application from going through because it is too similar to my mark, right? And when I say it's too similar, I mean that some consumers may think that that Drink It Up beverage is associated with my bar because I serve beverages in my bar, right? So it doesn't have to be exact, but they do have to be similar and associated in some way.
Okay, thank you.
Awesome question. Any additional questions? Awesome. Well, I do want to say that, everyone here who's on the call want to offer, a free 30-minute consultation. And what we'll do is we'll send this recording out to you. And you can review the recording again. You can share it with someone who you think may be interested in the information. And I'll also send a link out so that you can schedule a consultation if you want to talk about your specific situation, etc. So you can be on the lookout for that email coming this week as well. But I do want to thank everyone for joining, today's webinar. I think there were some good questions asked. And, some of the key takeaways is that a trademark is a symbol, a word, a phrase, or a design that can identify and distinguish a source of goods or services. There are different types of trademarks, right? So you're not limited in what types of trademarks you use. You can use word marks, sound marks, a combination of the two. You want to make sure that you register your trademark so that you actually have protection and you can establish your ownership rights. You also want to make sure you maintain your trademark. So a lot of people think that once they have the trademark application that they're all good, they own it for life. And that's not the case, but a trademark registration can go on forever, right? And it's different from other intellectual property rights, like copyrights expire after a while, but trademark can go on forever as long as you're still utilizing the mark. Another tip, make sure you choose a good mark up front and conduct a search to make sure that you're not infringing on someone else's work. A lot of people think that their mark is super creative, and then they go ahead and they see that someone had a similar super creative idea. So you want to prevent spending any unnecessary money and building a brand that you can't actually utilize down the line. And I would encourage you to work with an experienced attorney through this process, because the trademark application process can be deceptively simple, right? It may seem simple, but it's not really the case. Oftentimes correcting the mistakes that were made on the initial application costs you more money down the line. So thank you all again. I hope you enjoy the webinar, and I look forward to connecting again in the future.
Thank you. Thank you so much for your time.
Absolutely. Have a great day.
I definitely learned a lot. So I'm glad I was able to join this webinar, and it was learning about all aspects of trademarking and the process of it. It was very interesting, and I learned a lot.
Awesome. I'm glad to hear that. Makes me feel good. Thank you. All right.